Welcome to the 24th lecture of this lecture series regarding international arbitration practice. In the last lecture, we have begun looking at invoking arbitration under investment treaties. In this lecture, we look at a proper instance of a notice of arbitration which was issued by Chevron in the Chevron versus Ecuador dispute. Link to the notice is in the description to this video under the heading References. Please recollect that in the last lecture, that is lecture 23, we looked at 6 ingredients of a notice of arbitration under investment treaties. These 6 ingredients are fairly standard in investment arbitration. That is description of parties, including the claimants and the respondent state, factual background, which consists of preliminary aspects and claimants' investments, then the host state's breach of investment agreement, damages to the claimant, dispute resolution, and request for relief. We also saw in the last lecture that irrespective of whether the notice is a notice of intent or a notice invoking arbitration, these ingredients would be there in those notices. To establish this aspect, we look at the notice of arbitration in the Chevron versus Ecuador dispute. Just have a look at this table which compares the headings to those of the 6 ingredients we have mentioned just now. Please pause this video and note the similarities. Hope you have had a close look at this table. As you would notice here, serial number 4, that is damages to the claimant or the damages suffered by the claimant, has not been specifically dealt with in the notice of arbitration. However, the section regarding request for relief covers the relief sought, although damages have not been quantified. Now we will look at the Chevron notice. Before the first heading on the parties, there is an introduction to the notice. This heading usually covers the parties invoking the notice, the party, the host state against whom the notice is invoked, the specific provisions of the treaty under which the notice has been issued. In the Chevron issue, that specific portion states that it is Chevron Corporation and Texaco Petroleum Company, collectively referred to as the claimants, as the parties invoking arbitration. Next, the introductory portion states that arbitration is invoked against the Republic of Ecuador. Thirdly, it states that arbitration has been invoked under Article 6(3)(a) of the Ecuador US BIT. The BIT was, by the way, signed in 1993. Some notices combine this introductory part with the first heading, that is parties. Now, the first heading in the Chevron arbitration notice is titled Parties. This heading provides a description of the parties. It explains who the claimant is. In this case, there were 2 claimants, and so it describes their identity, their principal place of business, and contact details. It then goes on to describe who the host state is. Here, de jure means by right. Since international investment law derives from international law, these are terminologies borrowed from international law. This section of the heading describes that the Republic of Ecuador is duly constituted government of the people and territory of Ecuador, which is represented by the Attorney General of Ecuador. His address and contact details are also mentioned. Traditionally, the notice of arbitration in international investment law provides for Attorney General as the party representing the government. The next heading is factual background. Factual background constitutes a major portion of the Notice of Arbitration. In the Chevron notice, it is about 12 of the 19 pages. Now here we will provide a summary of Chevrons Complaint in this lecture. Texaco Petroleum Company, TexPat, entered into a concession agreement for exploration and production of oil along with a consortium consisting of the Republic of Ecuador and Ecuador's state-owned oil company, Ecuador. It had a minority interest in the said concession agreement. In 1992, TexPat's participation in the concession agreement ended and it negotiated a settlement agreement with Ecuador and Ecuador. This was in 1995. In that settlement agreement, TexPat assumed responsibility for specific environmental remediation projects corresponding to its minority interest in the concession. In 1998, Ecuador and Ecuador released TexPat from environmental liability, and the remaining responsibility were retained by Ecuador and Ecuador. TexPat entered into similar arrangements with the local municipalities. In September 2009, Chevron and TexPat issued the Notice of Arbitration stating that Ecuador breached the 1995 and the 1998 arrangements and is also colluding with a group of Ecuadorian plaintiffs and US-based lawyers who sued Chevron in 2003 in Ecuador seeking damages for environmental liability, called as the Las Agrio litigation. Chevron and TexPat also allege in their notice that Ecuador attempts to shift the liability of Ecuador to them for the pre-1992 liabilities and also allege that Ecuador wants to shift to Chevron Ecuador's responsibility for activities carried out post-1992, including the government's colonization and exploitation of the Amazonian region. Another allegation by the claimants is that collusive legal proceedings and conduct of Ecuador's judicial branch has been in total disregard to Ecuador's law, international standards of fairness, and Chevron's due process rights. All these, according to the claimants, constituted violation of the Ecuador-US BIT. Accordingly, the following reliefs have been claimed by the claimants. Declaration that under the 1994, 1995, 1996 and 1998 investment agreements, claimants have no liability or responsibility for environmental impact. 2. A declaration that Ecuador has breached the 1994, 95, 96 and 98 investment agreements and the BIT, including obligations to fair and equitable treatment, full protection and security, an effective means of enforcing rights, non-arbitrary treatment, non-discriminatory national and most favored treatment to observe obligations it entered under investment. 3. An order and award requiring Ecuador to inform the court in environmental litigation, that is the Las Agrio litigation, that TexPat has been released from all environmental impact out of the former consortium's activities and that Ecuador and Ecuador are responsible for the remaining and future remediation works. A declaration that Ecuador or Ecuador is exclusively liable for any judgment that may be rendered in the Las Agrio litigation. 5. Ecuador is to indemnify, protect and defend the claimants as regards that litigation. An award for damages cost to the claimants, including attorney's fees incurred in defending the Las Agrio litigation. Then moral damages award, then costs, interest and other just and proper relief. So more on this in the next lecture. Happy learning.